Good afternoon, ladies and gentlemen. It's great that you're coming to this panel despite it being lunch, late lunch, early afternoon of the Friday. I think you will agree with me that no matter what time this panel is taking place, it's incredibly important. We're talking about asset recovery developments in Ukraine, and that is a topic that's been on the mind of many, many people for only the very most important reasons there can be here. My name is Greta Fenner. I'm the Managing Director of the Basel Institute on Governance, which is also hosting the International Center for Asset Recovery, ICAR. We have had the privilege of working with Ukraine in relation to asset recovery since 2014. Things haven't gotten easier necessarily in the last months, but the problems we've had in asset recovery are not even relevant to mention compared to the other problems and the huge challenges that this country is facing. I am very happy to have a great panel, and I will start with the gentleman who's unfortunately on screen, but we are particularly appreciating that you could join us, Anton Korinevich, who is the Ambassador at Large for the Ukrainian Foreign Ministry and since September head of Ukraine's Freeze and Seize Task Force, which was set up within the Prosecutor General's office to help freeze, seize and confiscate Russian assets. We've got on my immediate left an old friend of ours, a very dear colleague from Ukrainian civil society, Katya Ryzenko, who is with Transparency International. She's the Deputy Director of Transparency International Ukraine, and I would say an outstanding expert on matters that we're discussing today, asset recovery being one of them. On the left from Katya is David Lim, Deputy Director for the fairly famous, I should say, US DOJ Task Force Klepto Capture. I always have to make sure that because you have another couple of klepto initiatives, so this is the Klepto Capture. But I think it's, I've heard your boss speak a couple of days ago, and I think it's an incredibly important contribution that you're going to make to our conversation. Together with Peter Czonka, who's on our far left, Deputy Director at the Directorate for Criminal Justice in the European Commission. And I think, ultimately what's happening in Europe, what's happening in the US are going to be very, very essential developments to determine how successful we are going to be to recover assets to help rebuild Ukraine. I'll start with you, Anton, in the hope that we will be able to keep you online for the whole session, but you never know. So I just wanted to ask you, Anton, if you could take us through some of the challenges that Ukraine has had in relation to asset recovery, and I would perhaps ask you to talk about them both in terms of asset recovery efforts before the war and asset recovery efforts since the outbreak of the war of aggression in Ukraine. If you could take us through some of these points, please, Anton.
Good afternoon, dear colleagues. I hope that the connection is fine. Of course, I'm very happy to be here today with you. It's a pleasure to meet colleagues in this panel and to discuss the matter. Actually, we were in DC several days ago with another mission on another legal issue, which is a priority for Ukraine. But nevertheless, today's conference, of course, is very important for us. So I think that what is obvious for us now is that the issue of asset recovery is one of priority for Ukrainian government and for all the Ukrainian stakeholders. I think that it is very important that the Prosecutor General of Ukraine, Mr. Andrei Kostin, gathered a group of Ukrainian government officials, Ukrainian law enforcement officials, and kind of renovated the activity of Ukrainian task force on seize and freeze of assets. And I think that this is something what we may see in the change of attitude and the change of, I would say, activity of Ukrainian task force, which we see now. And this
Coming back.
Recording in progress.
Before the war And if we take the situation, let's say, which and the conditions which were there in March, in April, and in spring. So first of all, today, a Ukrainian task force within the Prosecutor General's office, it is very important that it represents one voice of all the relevant stakeholders. So we do have in task force, which works under the auspices of Ukrainian PGO, all the relevant representatives of Ukrainian government and Ukrainian law enforcement agencies. We have kind of tried to change orientation to confiscation of Russian assets, mostly abroad, because we do understand that the biggest amount of Russian assets are there in other jurisdictions, in the European Union, in the UK, in the US, and that, of course, we are still working to have confiscation of Russian assets, of Russian perpetrators here in Ukraine. But we understand that the key point is to have confiscation of Russian assets abroad. So this is like a big task which we try to achieve, to have this confiscation of Russian assets abroad. And to have that, we have amended the procedures and the way how the task force works since September, as you mentioned, of this year. We have now the official signed instruction on how the Ukrainian task force works, and it does include four elements, four, let's say, subgroups working on different issues. So we have actual season freeze subgroup, we have a subgroup on sanctions, which hasn't been in the scope of Ukrainian task force before. And this is very important. We do believe that we do now have also the sanctions subgroup. We also have the subgroup on the criminal investigations and actually criminal subgroup, which encompasses our colleagues from law enforcement agencies. And we do have subgroup on drafting the legislation. So four subgroups, which we believe cover all the related issues which are important when we talk about asset recovery. I think that as of now, we have established a fruitful cooperation and good relations with our colleagues, task forces from other states. And it's a pleasure to see David here today. And of course, we have great relations with US Klepto Capture. And we do try to communicate and cooperate on all the related issues with our foreign partners. Apart from including sanctions into this asset recovery track, we also have changed a bit orientation, which was there in March, in April, in May, to not only work on war crimes and war-related crime, but also to work on ordinary crimes, which do have prospects in relation to dual criminality and recognition of this crime these crimes in other jurisdictions. I do believe that this is very important, because whenever we talk about assets of Russian, let's say, oligarchs, who support the Russian war machinery, for us lawyers, it is quite obvious that it's not an easy task to prove the complicity and the participation of Russian oligarch in commission of war crimes, which are serious violations of Geneva Conventions of 1949. But it is much easier to work on such crimes as, let's say, money laundering, which we do believe may be the case of many Russian oligarchs, and try to work on asset recovery whenever we talk about these ordinary crimes, which do have good prospects in relation to international legal assistance and international legal cooperation.
Okay.
So it was also the change yet to change this perception and to start looking broader, not only at war crimes at which we worked since, which we looked since 2014, but to make this perspective broader. And we have already gathered information and relevant list of how we call them key targets. So the key Russian alleged perpetrators of the crimes which do have prospects within the dual criminality. And we have gathered this information and showed it to our international partners for them also to work on this list of this target.
Okay, let me see.
Recording in progress.
Anton, can you hear us again?
We have also...
Anton?
I can hear you, colleagues, but
okay, sorry, we lost you for a moment.
Probably,
but go ahead. But probably if you can bring it to an initial conclusion in a minute or so, I will come back to you, promised.
Yeah, sure. I hope that I didn't talk only to myself all this time.
No,
we have also prepared the amendments to the national legislation, in particular to the Criminal Code of Ukraine, in relation to have confiscation as sanctions and to have liability for a non-application of sanctions, for sanctions circumvention. And the task force itself within the Prosecutor General's office does execute this coordinative role inside Ukrainian government, inside Ukrainian law enforcement agencies, in order to have all these important tracks in relation to seize and freeze activity concentrated, and all the relevant stakeholders to have one voice and one understanding how to work. I thank you.
Thank you, Anton. I think that I was extremely interesting, and you said a few keywords that I was hoping to hear, and in particular, from my perspective and what I've seen, I think you're thinking from moving from war crimes, as incredibly important that is, to also other crimes which may lead you to the money more directly, I think is something that I'm happy to hear. Now, we are talking Ukraine, and in Ukraine there is no discussion without giving civil society immediately an opportunity to voice their opinions. So over to you, Katya. What do you think about what you heard, and what are your own suggestions from TI and the civil society movement?
Thank you very much for the opportunity to participate today. And obviously, I guess I will try to give a little bit broader perspective on what Anton mentioned, that in Ukraine, as in a majority of countries around the world, it's not like we had a very great track with asset recovery before the full-fledged war started. And barely you can even find several cases of asset recovery that were successful, if you even can call them so, when Ukraine, during already independence of the state, managed to successfully bring back the assets. And just an example of, unfortunately, failure is Yanukovych and his family assets were frozen, after 2014, and still, for now, the war is going to maybe finally bring some of those cases, to some conclusion and hopefully return the assets. So I'm saying all of this to paint a picture that 24th of February we started basically with nothing much. And everything that Anton mentioned, a lot of this was built up for the last months. Ukraine, as any other country and representatives of European Union countries and USA, is looking even now for solutions on how to get it from frozen assets due to sanctions or whatever as a reason to the confiscation. But we did manage to go several steps further. We adopted several legislation, for example, amendments to the legislation on sanctions, and now we have established procedure, administrative procedure, where the High Anti-Corruption Court is involved where sanctions can be, where assets of Russians and related to Russian aggression, people can be confiscated. This is a very swift mechanism, and we as civil society have a lot of questions toward this, because the terms during what these cases can be considered are very short. The representation of the parties is questionable, but it is a procedure where there is the consideration within administrative code, and there is a decision of the court. And we already have 5 cases, actually, within this procedure. And Yanukovych is one of those cases that is being now considered in the High Anti-Corruption Court. So let's see what procedure will finish first, or, normal criminal one or this new one. Just the last sentence about this is that because it's so new, and basically the first case in Ukraine came in end of August, there is still the question, even if the court in Ukraine will decide and confiscate these assets, and if this asset is not physically only located in Ukraine, how and if it will be even enforceable and implemented in other jurisdictions, and how willing will be other jurisdictions to actually confiscate the assets according to the decision of the Ukrainian court. We will see that, plus there are still concerns if those people, oligarch or whatever, that are assets, whose assets are frozen and then confiscated under this procedure, if they will go to international court institutions, tribunals, or whatever, and basically say that there is no due process, that their rights were violated, and there is a chance that they will be successful. There is another procedure in place also concerning the forced seizure of property rights of Russia and its residents. This one is a little bit more tricky because there is no court decision involved, and if my colleagues from other countries sometimes have luxury of taking time, consider properly how to legally correctly approach some of the things, Ukrainian authorities, and I'm not saying it's good or bad, it's just the fact, have to act swiftly, and sometimes maybe rightfully so, even cut some corners. So under this forced seizure procedure, the assets of 2 banks, Russian related banks, were confiscated, and they already in international tribunals, arbitration, is of course saying that this was not due process and they want their money back. So there are a lot of things in place besides the normal criminal procedure where you can go through what Anton mentioned. Also, they are working with related crimes, not war, concerning crimes, and not crimes not with connection to the sanctions, but actually through the normal criminal procedure. They are still in place. Unfortunately, in Ukraine itself, we don't have any convictions, at least the last time I checked yet, because criminal procedure take years, maybe even tens of years, and we don't know when it will end with some result. And then, even if it does, we have to talk about how exactly those confiscated money to bring to Ukraine for its reconstruction. So I guess I will stop here for a while. And Greta.
No, I'm already looking forward to your next contribution, because the points you raise are incredibly important. Time is of incredible essence here, but we got to be careful to balance that necessity of urgency with finding ways of respecting the basic due process, rule of law. And yes, we need to be experimental. We need to push the boundaries as far as we can. But if we push them too far, we risk being so badly slapped in the face that ultimately it hurts Ukraine more than it helps. So I guess in a way, what the world could give us is more time, and that could mean more money for Ukraine to meet its basic needs, not only military, but every need the country needs, so that they are less under pressure to race forward with getting this money into Ukraine. That is maybe sort of a a side point here, but anything that helps make this slightly less urgent would be great. Now over to you, Anton, one more time before we bring in the US and the EU or the European Commission. What is your hope? What do you want the international community, the Europeans, the Americans to do to help you in your endeavor and to help in terms of going from sanctions to confiscation? What's your expectations?
Thank you so much for the question. And I think we already talked with stakeholders and with our partners how international community can assist us, in particular the work of EU task force. I think that all the key stakeholders do already have the understanding what are the needs and how do we move forward. I think that what is very important is the actions in relation to those people whom we call the principal targets and whom we included into this list of principal targets, and any action from.
With experience, he's back in 5 seconds. There you go.
Recording in progress.
Able to talk about confiscation of assets of Russian alleged criminals, in particular, or oligarchs, are criminal verdicts, judgments, convictions. And we need them here in Ukraine to be able to talk about confiscation in different jurisdictions, and we will also be happy to see them abroad. So we understand that there are two issues.
Two issues?
Recording in progress.
Corruption court.
Anton, can Can you hear me?
I can hear
okay.
you, but connection
can you do me a favor?
I think
you were just saying there are two issues, and then we lost you. Can you tell us what these two issues are to make sure we get them?
Sure. So whenever we talk about confiscation, we mean two issues: criminal confiscation and civil confiscation. Of course, Katerina.
Unbelievable. You get it. Yes.
Recording in progress.
We hope that there will be more. But of course, we understand that criminal confiscation is something what can lead us to confiscations in foreign jurisdictions. So that is why this is like the priority to build this possible confiscation issue on the basis of Ukrainian criminal verdicts in relation to ordinary mainly crimes with dual criminality.
I think David and Peter are nodding.
Recording in progress.
Thank you.
Thank you. Anton, I think we got your main points. You were primarily talking about civil and criminal confiscation, openness, I think, of international partners to explore every avenue possible to admit dual criminality. I will hand this over now to David and Paul and Peter. Why do I say Paul always? Paul's also a nice name, don't you think? And maybe I could ask you to kind of start with a shorter point first. If you can just give the audience here a quick update on where you stand in terms of tracing, sanctions, and then we will talk about legal avenues to go from sanctions to confiscation. So I don't know, I'll ask Paul Peter to go first because I've already butchered your name twice.
Okay, so on the EU side, and good to see you, Anton, and everybody else on this late Friday afternoon. It's, I think, quite impressive that we have a room more or less full to listen to us. In the European Union, We have 9 sanctions packages adopted as of today. The last one was adopted today. And we have added close to 200 names of Russian individuals and corporations to the list of designated people. And we have reached now almost 1,500 individuals and companies which are listed by the EU. And those 9 packages of measures essentially concern asset freezes, certain bans on financial services, economic and commercial transactions, prohibitions in relation to dual-use items, chips, etc. It's a very, very long list of measures that we have adopted since 2014. Now, as a result of these restrictive measures or sanctions, which are temporary and non-punitive by nature, I have to add from the outset, they are non-punitive and temporary. They are designed as temporary measures. They are not there to confiscate assets, and they are not a legal basis for confiscation. But the asset freezes can go on as long as necessary, and it's essentially the Council, our governance body in the European Union, that determines how long is as long as necessary. It could be possibly for a very long time. As a result of these designations, we have in the EU member states frozen close to 19 billion euros of private assets. And they are frozen in the EU, and our economic operators, including in particular central banks, have immobilized Russian central bank assets and also affiliated entities such as the Securities Depository, together with the G7 countries. So it's a collective figure running up to 300 billion. These figures are known, and our friends in Ukraine, they know that these assets are currently frozen or immobilized. Of course, there's a difference between private assets, corporate assets, particularly corporate assets which belong to the Russian state, and sovereign assets or assets which are those of the Russian central bank. Protections are different. And the way to get to them and to lift protections is different as well. So that's the result for us.
David, over to you.
Thank you for the opportunity to be here today. From the U.S.'s standpoint, asset forfeiture seeking both through conviction-based as well as non-conviction-based tools are things that we have done traditionally in the past in a robust manner. But what we have tried to do through the task force is to have a wider view of how we can approach the issue. I think a topic that Anton and both Peter have touched on is to be a bit more creative in looking at the type of crimes that we would seek seizure under. And so while money laundering and sanctions are still aspects, what you have seen over the last several months are efforts by the task force to really empower the export controls that the United States government and international partners have also rolled out. Because there are, at least in the US, forfeiture bases under export controls as well. And so rather than just seeking out and doing the one-off asset versus another, our central focus in deploying the various different forfeiture tools have been predominantly first and foremost to make a statement to the world that the U.S. is very committed in its effort to support the Ukrainian people in putting an end to this violence in Ukraine. We've done that first and foremost by some of the things that we're more known for, your luxury yachts, airplanes, and things of that nature. Those serve a couple purposes. One, first most, is to remove that asset from being something that the Russian oligarchs and the elites get to continue to enjoy. But they also serve as a very powerful tool in messaging to the facilitators, to the service providers, to the insurance companies, to all those entities and individuals that support the asset as a whole. Their cooperation through the messaging has helped us to identify additional assets that we may not have been aware of to begin with. And that's information that we constantly share with our international partners. But their cooperation also identifies other key players that may have escaped the purview of law enforcement's observations. Obviously, the criminal actions that we've taken against the oligarchs themselves, as well as their facilitators, additionally reinforce the message that it's not just about this specific asset that we see right here, but that providing services will have consequences and that we are serious about enforcing them and will flex every time that we have an opportunity to do so. So as we kind of move into the end of the year into the new year, I think that's what you should expect from the United States, that we'll continue to pursue the people that allow the Russian oligarchs, the government, to continue to enjoy their assets, your money managers, your procurement networks, people that have very specific skill sets that we want to neutralize.
I think, first of all, there is big money to be had, which is the tempting thing. Probably in Europe even more than in the US. We need to distinguish, I think, between, as you just did, oligarch assets, assets that belonging, although I kind of hate to use the word belonging to the Russian state, because we don't want this money to belong to the Russian state, but legally speaking, that is the case. We hear sanctions evasion is an option of getting at least some of this money back. There's been a interesting proposal called the exit tax, discussed in Europe. I'm not sure whether you want to point at that, but I think it's off the table already, which is good.
Thankfully.
I heard people talk about investing frozen assets and making gains out of the frozen assets being invested and so on. And I think, as this is the level of creativity and probably even a lot more creativity we will need. Now, in terms of your views, please, what are current legal avenues? And I think we already know non-conviction based, but point at these anyway. And where's your current thinking in terms of where are legal boundaries that we could push further while remaining respectful of human rights and due process? Peter, Paul, or David, please start.
Thank you, Greta Hansel. Well, obviously, we all agree that Russia should pay for the damage that they have created. And I think we all agree that Ukraine deserves to get all the support that we can offer. And I wanted to say this here publicly and also again to repeat it for Anton and his colleagues. We will do everything that we can to support you and push the boundaries of EU law to the limits of legitimacy, of decency. And since we stand up for rule-based international order in the European Union, and we actually do stand up for fundamental rights and the rule of law, and discussions were quite heated this morning about the balance between privacy and access to information for beneficial owner registers. This is one of those areas where we will have to balance, indeed, the interest very carefully. But what I can certainly tell you is that we are very engaged with our member states in a discussion based on an options paper that we have submitted last week to our member states, to the heads of state. In fact, it's on the request of the heads of state of the EU that we produced this options paper, in which we go through the various options. And the first and foremost, of course, is criminal confiscation. But there are things we can do there. So before we rule out criminal confiscation, actually there are many things that we could obtain. It's true that it's not a great success story in the EU either, or anywhere in the world for that matter. I remember this from the FATF times. By the way, the FATF 40 recommendations were extended to terrorist financing in this hotel 20 odd years ago, in the same room. I was here. So much about history. So the criminal confiscation procedures that we have in the EU, they essentially all require that prosecutors demonstrate a link with a specific offense, and that we obtain a conviction first, and then link that conviction of a specific offense with the property, the proceeds that would be confiscated. That is not a great success story. Where we are now going beyond this traditional approach is a proposal that we submitted on the 25th of May to our legislative authorities, that is Council and the European Parliament, to extend the list of non-conviction-based confiscation, and also something that we call unexplained wealth orders, UWOs. In the non-conviction-based confiscation orders, what we ask our member states to do is to enable confiscation in cases where the proceedings could not be finalized for some reason. So criminal proceedings have been started, they concern a specific person, and proceeds have been seized, criminally seized, but for some reason there is no judgment pronounced by a court. The person absconded, was granted immunity, died, became ill, seriously ill. There are a number of 6 cases mentioned in the text. In those cases where it would have been possible to confiscate had the case gone to its end, we can confiscate. We hope that this will be on the books very soon. And then the next extension is we can confiscate property from third persons, bona fide third persons, to whom the property had been transferred. So Katja and others mentioned already, Maria in the previous plenary discussion, that this current practice of transferring property to third persons, the wife, the cleaning lady, the mistress, the boyfriend, so that the link is cut between the property and the beneficial owner or the owner. That text will enable us to go after the property in the hands of third persons as well, if one can demonstrate that it was intentionally transferred for the sake of concealing the property or avoiding confiscation. And the third element in the text is unexplained wealth orders, which is that we can impose, if there is a suspicion of some criminal activity without actually going into detail, that is not pinning down a specific offense, then we can go and confiscate that property. Now, to the offenses list to which this new regime will apply, we have added sanctions violation or circumvention of sanctions. We have extended, we revised the treaty in a matter of a few weeks to extend Article 83 of the treaty and added this new offense. So in this new offense, we redefined the notion of proceeds. So the directive proposal that we submitted last week, 28th of November, broadened the definition of proceeds so that if anybody, including oligarchs, attempt to circumvent the restrictive measures, the whole list, by participating, by instigating, by doing it, then the frozen assets themselves will be subject to confiscation.
I'm super glad to hear that. There are some real tangible proposals, and I think it almost kind of brings me to what I wanted to ask you later, but I'll come to that because I think, and I don't want this to sound wrong, but the tragedy that we're living and the Ukraine's living must at least allow us to bring the fight against illicit finance forward. And hearing what you just said, Peter, is exactly the kind of response that we must really have, because if we don't use this opportunity, then we've really failed the people of Ukraine. So, David, how do you intend to use this opportunity?
I'm glad you asked that question. I think it's very important for everybody to hear, and it's certainly a talking point that we try to make every single forum that we have, that international cooperation is not just a passing thought. It really is the bedrock and cornerstone of every single action that the United States has been able to accomplish to date. We are very aware that the overwhelming majority of these assets, specifically related to both the private and the state-owned, are not in our shores. And in the past, what you have seen is, although we have these tools that Peter had outlined, others would very much want, especially non-conviction-based forfeiture, there have been challenges in being able to get foreign partners to agree to accept our seizure warrants. Because the United States, much to what people may think, the contrary notion, we can't just go to a foreign country and grab something ourselves, whether people think we can or not. The reality is it all is dependent on foreign cooperation. And if you have a sanctions program that is mismatched throughout the world, and although we have a robust view of violations with respect to one particular country, but if the foreign country were the asset or the individual, if we're seeking extradition or evidence in order to get a case across the line, is housed in a foreign country that thinks differently, it's impossible for the US to advance and finish what it started. That has dramatically changed in the last 10 months. I absolutely agree with you that, not to make light of what is happening in Ukraine, but if there is a silver lining, the message should be that the world is together in their support of Ukraine. The task force was something that the president announced in his first State of the Union. It was immediately created thereafter. It's something that is housed out of the Deputy Attorney General's office, which effectively means we are able to pull from the resources of all of not only DOJ, but every law enforcement entity. What's changed dramatically back here in the States is the intensity with which we pursue a target. In the past, if you have one specific U.S. Attorney's Office or a main justice component that specializes in illicit finance, the lens is narrow and the focus is only on illicit finance for the basis for forfeiture. By drawing upon experts across the department, from tax division to criminal division, national security division, everybody's getting very creative in how we attack a problem. The flow of information sharing, not only with our international partners, but domestically, has ramped up at a level that I've never seen. And it's only going to get better, because I think there is this acknowledgement across the board with all our partners overseas that success is defined very broadly. It does not matter if the United States are the ones that seek and are able to forfeit a fund or an asset, as long as everybody gets what they need in order to be able to do it if they're in a better position to do so. We work with Anton, we work with Peter and his group Freeze and Seize in the EU. There is a robust desire and actual exchange of information to fill in the gap and to help each other be able to create a clear picture for each of our priority targets.
You bring in another point that I think is actually super important, David, because one thing is to kind of push the world to adopt, frankly, legal tools that have been around in some countries for a while and maybe go further. The other one is the intrinsic motivation today to find a way to respond, for example, to a non-conviction-based forfeiture execution request, which we have come across this hurdle over and over and over again. And if there is a willing party on both sides, you usually find a plug that connects the systems, right? So I think if there is nothing, if nothing else, there is a stronger motivation now. Absolutely. It's a bit sad, I mean, massively sad that we needed the war to happen, but I hope this is going to be an ongoing development. And the third point you made, new laws where they don't exist yet, but more resources, really more resources, because the few people around the world that work on this, it's not going to be enough to sustain that momentum, because every single case still has to be won for itself, right? So, I mean, it's not just new laws. There need to be people who are going to enforce them. Anton, if I can turn back to you, if you hear me, and maybe maybe you want to switch off your camera and we can see if we lose you less frequently. Because it's been, okay, that's not a good idea, maybe. Okay. Okay. Just stay where you are. Don't do anything. Anton, when you hear what we've just heard from Europe and the US, does that sound like what you were hoping to hear, or are you waiting for more to come?
I think that we are happy with what we have from the US and from EU, and as I said, we appreciate the cooperation which we have, and I'm all happy to see better here. I mean, with the EU Free Task Force, we do have good relations, great relations with whole group and with subgroups, with different ones. So I think that this issue of which Peter mentioned, this criminal confiscation, is really something we don't.
Recording in progress.
For our colleagues abroad to people to work, but also, I mean, of course, we, as I mentioned, our end goal is confiscation, and confiscation, of course, meaning the confiscation abroad, because we do have Russian money in Ukraine, we do have Russian assets in Ukraine. We will tackle them, and we are tackling them with both criminal and civil confiscation. But
Okay, well, now we're even out of Zoom, I think. No, give it one more try.
Recording in progress.
Yeah. Can you go about 1 minute back, Anton, and start there again, if you can hear me, please? Sorry, this is terrible.
yeah, I can hear you. I pretty much hear everything what you say. I said that we are happy with the level of international cooperation, which we do have with us, with you, Season 3 Task Force. I'm happy to see better online, so I don't know whether you see me. I can see you, and it's great. The cooperation with Task Force Klepto Capture, with EU Season 3, both with the whole Task Force group and with subgroups, in particular on criminal matters. So we'll build them. We'll building this cooperation. It's fruitful. I think that better, a very important issue, and the key issue, criminal confiscation, and need to have confiscation.
Recording in progress.
Peter made a very important point.
US and EU.
Anton, start again where you said Peter made a very important point about criminal confiscation, please. And maybe you want to still try to switch off your camera. I don't know what it is.
Yeah, okay. So Peter mentions this important issue. We are happy with the level of cooperation. We are happy to have you guys with us. And let's try to see how to have confiscation. And let's try to see how do we work on that person's key targets, which we provided to our colleagues. I thank you.
Thank you, and apologies for the technical issues. I think, Peter, are you raising your hand? So I'm going to give you a quick moment to react. And Katja, I would like to hear also Katja's view on what we've just heard from Peter and David. And can I also start engaging the audience, because now's the time to start thinking about the questions. And we will open the floor for questions in about 5 minutes, including, if we have the possibility, maybe occasionally 1 or 2 questions online. But we have to see how that goes, because I think we have a lot in our room. Peter and then Katja, please.
2 quick comments, if I may. First, on tracing the assets of listed individuals, and I'm talking about private persons. What is important is that our member states, also outside the EU, mobilize all the relevant authorities that they have. For now, what we mobilized is the asset recovery agencies. So by adding the offense of circumvention of sanctions to the list to which the confiscation regime will apply, we mobilize the asset recovery agencies to actively, proactively trace the assets of these people. By making sanctions violation a predicate offense for money laundering, we mobilize FIUs, so that FIUs can also filter the information and pass it on to ARROs and to the sanctions authorities, which usually in our member states are ministers of foreign affairs. So this is really important that we identify which are the authorities in the member states that have to do this. Second point, if we manage to identify the offense of which the person could be convicted, and this is really a backward logic now. We're talking about having the assets, but looking for the crime. That would be a great achievement. And this is what we have done. We have asked our agencies, Europol and Eurojust, to run the list of then 1,200 names through their databases. Operation Oscar at Europol has thrown up a number of cases. Some cases dating back to the 1990s, old corruption cases, old embezzlement and money laundering cases. If we find the evidence, confiscation through criminal procedure will be possible. New chapter, sovereign assets. This is a very, very different ball game. Here, under custom international law, protection supply. One cannot confiscate Russian central bank assets without due process and all the legal safeguards. So the idea that we flagged in the options paper for our member states, and this is under discussion, so don't take it for granted, is that we would block these assets as long as necessary, but put them into an escrow account, into a financial instrument, a financial structure, like a trust fund. It has been done in the past. Afghanistan, it's the Swiss who run it actually. And then try to obtain a fair and stable benefit out of it, as long as it is frozen. Put it on the market with active management, it will produce some benefits. And then the frozen assets will be only returned, and they have to be returned under international law, if there's a peace agreement and a reparation agreed by the Russian Federation. So in return for the reparation, then we would release the frozen assets. That is the current idea in the EU. Thank you.
Thank you for bringing that in, because we have a bit neglected that part about the central bank assets. Katja, you happy with that?
I guess I will start from the end, because yes, it is a very touchy subject, and we in Ukraine, at least experts who are talking and working with this topic, completely understand that political statements aside, this will be even more challenging task than the individual assets and the corporate assets. But we do see, our end goal is still to get all of those to work for Ukraine as soon as possible, but the sovereign immunity doctrine is in place, and we can dispute how outdated or not outdated it is. We do also, I want to underline, we do also understand the political and economical implementations here, besides the legal possibilities. Obviously, countries where there is these type of assets, they are worried about how they will be perceived if they do break this doctrine of sovereign immunity. But I think that, actually coming to my next point, that the creativity is nice in the sense of creating something new, how to improve and make the existing legislation more effective. But I think there is still a little bit of room to go for how creative we can be within the existing legal framework. Because we definitely in Ukraine, and actually from our colleagues from Transparency International European Union, support finally some changes to directives on confiscation of European Union on anti-money laundering package, definitely overdue, and we're glad to help with the war to finally push it over. But we think there is still, meanwhile, those all go through the due process, both in European Union and in the United States, there is space to see what can be done within already existing possibilities, practical approaches in the separate jurisdictions. And non-conviction-based confiscation is something that Transparency International talked about even before the war, and when, the 24th of February. And when the 24th of February happened, and it's great that it is considered more seriously and forwardly, because we heard a lot of countries and representatives of the countries saying, no way we will ever look this way. So that is definitely something we're looking forward to, because Ukraine does have civic forfeiture laws. So would be nice if our European and other colleagues will follow through. And just that last one, I wanted to say that sanction evasion, I do understand what Peter said, and basically I think what David also agrees on, that these are not punitive measures, but politically was created this feeling for Ukrainians and for a lot of people in the European Union and United States that we are freezing that to make Russia pay. And we all here understand that this is legally is not as easy as it sounds, a nice political statement. So I think the sanction evasion mechanism can be at least somewhat addressing these expectations that not only Ukrainians have concerning Russian or Russian-related assets. And again, how it will be framed is another concern, but definitely what Ukraine, I think, will wholeheartedly support. Thank you.
Thank you, Katya. So we have a couple of questions. My goodness. Okay, many questions. Why don't we start with the gentleman here, the front 3 rows, because they came to pick up the stickers, so that's their advantage now.
Thank you.
Please, and could you tell us who you are? And
my name
where
is
you're
Amin
from?
Hussein. I'm a journalist, investigative journalist, based in exile. I'm originally from Azerbaijan, most kleptocratic regime in the world. But my questions to all of you, because first questions regarding like human resources of law enforcement and another affiliated agencies which is supposed to track these assets, because we met with your colleagues in 2018 in Copenhagen, an anti-corruption conference with people from FBI, from national crime agencies, from French affiliated special agencies, and all of them complain for guys. When we ask why you do not, we provide you with lots of information as like civil society or investigative journalists, but you put small fishes like some cousins of president, not by president himself, like Aliyev. They say, for guys, our biggest problem, we don't have capacities. We don't have, like, we are looks powerful, like FBI, but it's only 3% or 4% work in the unit, and we can't manage to do a lot of things. It's lack of financial sources, lack of human resources. My questions to American and European government representative, guys, did you manage to solve this problem for the last 1 year since the war started? Or you again to want to survive this problem with this limited Superman or Superwoman resources? Questions to Ukraine, as like for civil society, do you have capacity to also track these resources? Because as like we Azerbaijani investigative journalists and civil society leaders which is work on anti-corruption, we don't have capacity. We have capacity, but we have a lack of funding, and we ask US and EU-based donors for, guys, we give you a list of these violators. Could you do something? And we need some kind of support. Nobody in reality interested. Why it's nothing changed? And last questions regarding the change of the legislative system. You say you now freeze these assets, but you don't know what to do next. But still, Russians oligarchs and Putin criminal regime using like American, US financial system. They're using European financial system. They're using still SWIFT to launder billions every month. And guys, to be honest, you didn't do anything. You show me one simple example what US changed with this legislative, because biggest gray zones is US-based some states, in some like offshore EU-related territories? Thank you.
Okay, thank you. I'll give you a little bit of time to think about that comment. There's a lady, two ladies in the front here.
Thank you so much. Thank you for a very fascinating discussion. I've got two questions for Peter.
Can I ask who you are and where you're from?
I'm so
if you don't
sorry.
mind?
Franziska Christen. I'm a lawyer in private practice in London. The sanctions packages that have been adopted in recent months, they've led to the closing of financial spaces in large parts of the Western world. But many parts of the world are still open for business, the UAE, Israel being sort of the biggest culprits. What pressure can be brought to bear on those jurisdictions to stop them from being these safe havens? I suppose the US and the EU, what can be done? The other question is, Peter, you mentioned at the beginning the temporary nature of sanctions measures, and I think that links with the idea of sanctions being designed to change behavior. I mean, that certainly is a part of the UK's financial sanctions architecture, and I think in the US it's very similar. What is that change of behavior that you are looking for, and could a voluntary relinquishing of assets on the part of those who are designated be part of that? Because that could certainly deal with a lot of the difficulties associated with confiscation. So I'd be very interested to hear your views on that. Thank you very much.
Thank you. Can you just...
Hi, my name is Sama Salman. I'm a Sudanese in the private sector in Khartoum, Sudan. I'm based in DC. I'm also part of a working group on anti-corruption in Sudan. My question is this. There is something called a concept we call blood gold, which is gold that is being mined out of West Sudan. And our biggest militia leader, General Hamdan Dagalo Hamiti, the number 2 autocrat in Sudan, has cut a deal with Prigozhin and the Wagner Group to exchange gold for military training and weaponry. We've seen reports that a lot of this gold is smuggled and then goes to Russia and then fuels the war in the Ukraine. You've probably seen investigative reports out of outlets like CNN and other outlets on this. So my question, just to try to be brief, this is a big issue, but it's let me try to make it simple. We've been able to trace the movement of this gold through countries like the UAE into Russia, but then we don't know what happens after that. What sort of mechanisms and what sort of organizations would help us put forward some claim against the fact that this gold is being used to fuel the war in Ukraine, and to put a claim on these assets and recover them for the benefit of the marginalized groups in West Sudan?
Okay. We're doing a second round of questions in a minute. Who would like to go first with at least an attempt at responding to some of the points raised? David, do you want to have a...
Yeah, absolutely.
Thank you.
So we'll take this from right to left. Sir, appreciate your question. And if I understand it correctly, at its core, what you're interested in learning about is why is the U.S. government and others not going after the big fish, if you will? And I would say we are. The public actions that we've taken to date are against Russian oligarchs that everybody in this room is aware of. Your Oleg Deripaska, your Abramovich, taking them to court, whether it's in the form of charging them for crimes as we've done in Deripaska, or seizing their assets as we've done for a number of others, are our way of showing and demonstrating to the world, but that nobody is too big to not fall within the scope of what kleptocapture is trying to do along with its partners. And I think that's a consistent message that you will hear throughout all of the partner countries, that we are in fact, whether it makes it to the public news or not, it is in fact something that is a priority for us, because we do understand that there is a public messaging benefit for not just going after the smaller actors. With respect to smaller actors that we do go for, or I will say people that are not as well known, Last month, for example, or in October, the US government, in coordination with fellow partners in the EU, effected the arrest of a number of Russian procurement agents, and that made it into the news and is public information. You may not know their names, but they're big players in a space and only a handful of an example of a larger problem that individuals and entities continue to provide services to the Russian elites, to the Russian government. And it is a priority for us, as I mentioned earlier, to shift our focus away from the ostentatious oligarchs who we will continue to investigate, but we will focus our intention and our efforts on trying to eliminate the problem. It's not sufficient enough to just eliminate and take somebody's asset. There's always going to be more, unfortunately. Our added value in this course of action is to try to disrupt the networks that support these people with the special skill sets that they have. With respect to your question, and I think it's more of a academic or philosophical large question of what is the change in behavior that we're looking for. The message that the sanctions programs and the way in which they're rolled out, either with the EU or with the United States, is to affect specific sectors, as you've pointed out. Where we began with sectoral sanctions, now we're closing the loops, and they're in an escalatory manner. They are specifically rolled out in a way to eliminate the incentive for certain industries to provide services towards critical assets and streams of income. And it's something that I know, I can't speak for Treasury Department and State Department who controlled the rollout of these sanctions, but there is an effort to mirror against what is going on in Ukraine and to increase intensity with each step. Our hope through enforcing not just the economic sanctions that people are traditionally used to being enforced, but also enforcing the export controls that fall under the gambit of sanctions at large, is really to cut off the war machine in its resources, both in the parts that they receive, as well as the financing that they have. And the last question, I think it was the mechanism for tracing really at the end of the day. One key point that I hope is a takeaway for today's meeting is that international cooperation is at its highest when seeking to combat corruption and illicit finance. Many of the transactions, financial transactions throughout the world, go through the United States and Manhattan, but not all, and certainly not before they end up back in places like Russia. They're more likely and just as likely to hit off of partner countries. And now, as Peter pointed out, the robust engagement of our respective FIUs to be a lot more intentional in what they're looking for gives us better clarity and a better chance at identifying where the money goes ultimately.
Okay. Peter, I don't know if you want to add to that, if you could, and then Anton, I know you also want to say something, so after Peter, we'll switch you on again. Thank you.
I'll be very quick. On law enforcement capacity, I think it's a very good point. We need to come back to this. It turns out that going after sanctions violation was not a great priority for our member states for the last few years. It was on nobody's radar screen. We had barely a dozen investigations per year in the 27 member states of the EU. Now, this will increase, partly because of the priority that our governments are giving to this area, and second, because we have requested that they put the necessary resources into it. So they shift resources from other areas. So it's reprioritization in the law enforcement and prosecution sector. And some governments in the EU even suggested that the European Prosecution Office, which is a single EU prosecution office for fraud against the EU's budget, should be given this task to deal with sanctions violation. We'll see where it goes. Second point, the countries outside the EU which may still be open for business. There, it's for now only political pressure that may work, and we have detected indeed a number of sanction circumvention activities going through certain third countries, some more frequently than others, and so the pressure has started building up on these countries. At some stage, we may need to come to a more structured mechanism, like the FATF has done with non-cooperative jurisdictions. So grey listing, blacklisting, ultimately cutting off from the financial system. I'm not saying this will happen, but this is one idea I think we ought to discuss. And what behavior change should these sanctions trigger? Well, stopping the war would be one that we would very much welcome. And second, obviously, if the Russian government and the oligarchs voluntarily give up their assets, frozen or immobilized or blocked any other way, that would be also very positive in view of a future settlement. Thank you.
Yes, I think that would be a great scenario and would probably be the most efficient. Anton, can you hear us? Do you want to come in now? Let's hope we can have you for a minute.
Yeah, I will be brief due to these technical issues. First, it is really important to see actions from our foreign partners in relation to such big players as Oleg Deripaska, for instance, and others. So, I mean, we are really happy that the movements are there. And second issue, and I think it is a very important one, and I hope we can get it as a takeaway from today's meeting, on the issue of compensation mechanism and in general compensation of the damage caused by the Russian war. I would like to say that it is important that our key partners like EU do have consultations with Ukraine, because in Ukraine we have a concept of compensation mechanism which is being delivered by the Ministry of Justice of Ukraine. And the team has worked, as you know, on the General Assembly resolution on the issue of compensations and establishment of the International Register of Damage. And I think it's a bit different from the ones which we may see from Brussels. But I'm not saying that the issues are really serious ones. I just say that it might be needed that my colleagues who work on that matter, it's not my job, it's not my piece of cake, but my colleagues from the Ministry of Justice sit together with EU to see how to settle this compensations issue for getting the real, real end goal to have compensations from Russians, in particular by means of confiscation of assets. So we do appraise all the efforts. We do support all the activities which are being done. And I think that in relation to compensations, my colleagues from the Ministry of Justice will be happy, and they are already talking with not only EU colleagues, but colleagues from other states, from other jurisdictions, to settle the compensation mechanism, which would be, feasible. I thank you.
Thank you, and it even worked without technical interruptions. While the microphone is wandering, I'm going to take my moderator's privilege for 30 seconds and say one thing that I hope in the EU and the US and other countries we can also think about is there are individuals who have their assets frozen, who either are directly part of the political elite or who have financed the political elite that has decided to wage a war. They are committing war crimes directly or indirectly, or aiding and abetting. And those war crimes are causing destruction, and I'm talking infrastructure, but also costing a huge amount of life. And there are certain countries, Ukraine included, that knows a damage compensation element in their legislation. Almost every single country I've talked to, I hear, okay, Ukraine may convict someone for war crimes, may even have, in a court judgment, a damage compensation point, but we will not be able to confiscate that person's assets in order to pay for the compensation, So can we think about that? Because emotionally, frankly speaking, and we shouldn't be led by emotions in law, but emotionally it makes a lot of sense. And personally, I think it would also be if we could find legal means, because we all know that criminals have to pay compensation for the damage that their crime has caused. So it's not completely wrong, but there is no legal plug, I think, at this point. So just encouraging you, and that's my privilege. This lady here has had her hand up. Oh, okay, microphone over there, and then we come to you. No, go ahead, yeah.
Good afternoon. My name is Roland Pap from Transparency International EU. We do know that for the... Can you hear me? Yeah, okay. So we do know that in some member states the tracing and the seizing is more active than in other member states, and also when it comes to even more like going to the court and essentially, like eventually at the later stage doing some confiscation, the member state authorities need to really proactively do that. Now some member states do that, others maybe not. And this is a question of like what exactly can be done to make sure that all member states are doing their job. And this question goes partly to the Commission, but also to others, because maybe, I don't know, what is the role of civil society or others to make sure to put pressure on those member state authorities that they proactively do this job, what they have to do. Thank you very much.
I think the role of civil society in triggering some of the tracing and how you've found and were able to freeze is an important point. Maybe Katja, you want to speak to that? We've got one more gentleman, and then we're coming to this lady here. No, just don't touch it, just talk.
Hi, my name is Nurul Rekenbek, and I represent Freedom for Eurasia organization. My question is actually regarding the sanctions evasion. So it's when we talk about secondary sanctions, there are countries that help Russia to evade sanctions. And maybe like if we talk about example of Central Asia. So how serious are the secondary sanctions that's been talked about? And what are the effective mechanisms of monitoring? Whatever is happening in the customs union, for example.
Thank you. Now this lady has had her hand up. I'm just looking. Who else we need to take into consideration? We've got, you've had your hand up for a long, you've had also your hand up. Okay. Sorry, we got to cut it at some point. So go ahead, please.
I'm Ana Gomes from TI Portugal. I would like to ask, how are you dealing with member states in the EU? I mean, and EU is US and also the EU, of course, that have, through these golden visas, given resident status to many of the oligarchs and families, or even worse, in the case of Portugal, given the nationality to people like Abramovich, Rappaport, thanks to false certificates of the favorite rabbi of Putin, Alexander Boroda. How is the EU dealing with that, apart from, of course, the other crucial questions that we put about the efficiency in the seizing of assets?
Okay. I just looked at my watch, so wait a moment. We were going to take this turn. If there is more time for more questions, we will. But let's start with this round first. Katja, do you want to talk about civil society asset tracing and how that has played a role?
I actually will use this opportunity because I understand that maybe in Ukraine we have slightly different experience in the sense that in Ukraine we have a very robust, I like this English word, civil society who are pretty active and often very specialized sometimes in the topics. So we are being spoiled by being included in a lot of conversations. And for example, with task force that Anton Koronevich is representing, quite recently we've been invited to the working group with another civil society organizations to work together with Prosecutor General's office and with the task force on a number of questions, just as an example. But also not only Ukrainian organization and investigative journalists are actively working with asset tracing and helping task forces, European Union one and Ukrainian one, to provide information, what they are discovered. Transparency International in general also participate in this exercise. So we do have civil society, do have an active role in that. If I talk about Transparency International Ukraine specifically, we're majorly focused on policy development and getting to the specific countries. We actually work even with specific countries with the help often of some of our friends in European Union or United States, and we target those who have, issues maybe on complying as effectively and as involved as some other countries. So we do both from advocacy point of view and specific policy development point of view, not only within Ukrainian borders. Thank you.
And I just want to take that opportunity to thank Katya and her fellow civil society partners in Ukraine, because it is really good to work with you, because you so know what you're talking about. And it is really such a constructive and meaningful conversation that we have and everyone else has with you, and that you are bringing to the government. So it's really outstanding. And I think you actually all deserve a round of applause, please, for civil society in Ukraine. They are really top notch. Peter, do you want to start responding perhaps to some of the European-related questions, or whichever one you want to pick?
I'll take Roland's question first. Obviously, the Union and the Commission specifically has a whole toolbox for ensuring that member states implement EU law. We start with dialogue, then letters of formal notice, and then we take them to court eventually. And then there is a court judgment obliging member states to correct those deficiencies. Now, this may have happened yet in the case of confiscation. The next piece of legislation that is coming on confiscation will be very extensive. Will require a lot of change in most member states. And I open a parenthesis here. Our member states do not recognize routinely civil forfeiture orders among themselves. So the Irish forfeiture orders that come to the continent or the Italian preventive confiscation orders are not routinely recognized by our members. There are exceptions to that. France recognizes, for example, the Italian ones, but routinely the standards are very different. Civil is balance of probabilities, civil procedure, criminal is beyond reasonable doubt, it's a criminal judgment. So there is no equivalence between those two types of confiscation and forfeiture. That is a problem. We hope that the confiscation directive will be implemented swiftly. We are still in the negotiation phase with Council and Parliament. And we see some issues already now. On golden visas and passports, we do see the problem. We have a list of countries which offer such deals. There is no proper EU competence in this area, but the commissioner, my commissioner, Didier Reynders, has written extensively now to the countries concerned, detecting the loophole and asking them to close down those loopholes. Now, some of them willingly accepted, others refused. I'm not sure what is the situation with Portugal, but it's clear that there are some member states where this is a big problem. And where entire sectors of the banking industry is dedicated to Russia as well. So we do see the problem, and we will do our best to close it down. And I can only replicate the room here. TI Ukraine is wonderful. We invited them as well to the task force of the European Union. So thank you very much for your active cooperation.
I think there's a question on secondary sanctions, and I'm glad, sir, that you brought that up. They are incredibly powerful tools and understandably draw a variety of different responses from people, especially in the context of U.S. enforcing them. It doesn't require necessarily a U.S. nexus, but we, rather than seeking criminal penalties, will utilize a variety of different toolboxes Peter had mentioned. They are very program specific. They are things that we are considering and very much at the forefront of things we're thinking about.
Thank you very much. I would like to bringing this, unfortunately, to a conclusion. And I know there are a lot of questions in the room still, and I'm sure our panelists are happy to maybe stick around for another 5-6 minutes, as long as you can. So feel free to rush up here as soon as I've concluded and, locked them to their chairs with your questions. I'm out of here. But just before we bring it to a conclusion, I just wanted to check with Anton, because it's hard for you to come in spontaneously. Is there anything you wanted to add to the debate in terms of concluding remarks or last points?
Just maybe a brief thing. Civil society is of crucial importance for us. And as Katerina mentioned, we are looking forward, and we are already actually cooperating, and we are looking forward to enhancing this cooperation. Because on the matters of accountability and on the matters of compensations and cease and freeze, I mean, there is really one voice from everybody in Ukraine. So just also for our audience, from a Ukrainian government's perspective, to mention that cooperation with the civil society is of key importance for us on all the tracks, which are related to accountability issues.
Thank you, Anton. I think there are quite a few people who in this room who are very happy to hear that, and I hope we can hear the same kind of commitment from other governments. Did any of you want to bring in any last points? Otherwise, I'm going to say a huge thank you to our wonderful panel. Thank you so much for being here. It's an incredibly difficult conversation to be had, and I have to say that the first few months where this conversation was held primarily in newspapers and you know, slightly populistic, if I may say so, political statements, it was a quite worrying conversation. I'm really glad that with this panel and some other conversations I followed, we're starting to bring it back into a direction which is very ambitious, and I hope we can continue to be incredibly ambitious, but only ambitious to the point that we don't create damage to our fundamental human rights due process for which our societies have fought for so long, and which are the very fundamental things that are under attack now in this war, so that we don't create more damage to this by wanting to help Ukraine as much as we really need to do that. So I think I'm really grateful that you had the time and you brought in your thoughts, because it's critical we push this forward. We will continue to ask more from you all and ask more from you, but I think it's for the right reason, and if we can continue to have these kinds of substantial, you know, really substantial conversations, I think we will get there, and hopefully we'll find that money to really rebuild Ukraine and make it a strong and beautiful country again. So thank you very much, and have a lovely afternoon, everyone. Thank you.